On behalf of the CARIPI team and the EU IPO, we welcome you to this webinar on intellectual property mediation, which is being hosted in collaboration with the World Intellectual Property Organization and the Caribbean Court of Justice Academy for Law. I am Ms. Ricky Camacho, the Registrar of the Antigua and Barbuda Intellectual Property and Commerce Office, and I'm delighted to be your moderator for today. Just before we start, some technical details. Firstly, I apologize for the brief delay in beginning this morning, but we ask that you please write and post your questions in the chat section of the Zoom so that they can be tabled during the question and answer session at the end of today's presentations by our experts. You will find the chat icon in the bottom of your screen or bar. You can also raise your hand and ask questions directly. The language used today will be English. However, there is also available simultaneous interpretation in Spanish. Please let me thank our translators for this. To enable interpretation, please click on the globe icon on the bottom bar of the screen, of your screen. There will be a brief 4-question survey, which you'll receive by email, and the link to which will be posted in the chat. We ask that you take your time to complete the survey. This is your opportunity to let us know which of the topics presented today and you would wish for us to expand on in future as workshops or further webinars. I'm delighted to say that we had over 200 persons registered for today's webinar, and most of the CARIFORUM states are represented. For the sessions today, we have a cadre of experts who will provide valuable information on intellectual property mediation, global and regional context. We will open today's session with some welcome remarks from our host for this event. First, we will have brief remarks by Mr. Leandro Toscano, the head of the Business Development Unit of the World Intellectual Property Organization, Arbitration and Mediation Center, followed by remarks from the Honorable Justice Anderson from the Caribbean Court of Justice, CCJ Academy for Law, and finally, Mrs. Alexander Marr, project leader of the CARIPI project. I will now allow, or can we please hear from the first speaker for the introductory remarks. Mr. Leandro Toscano.
Thank you very much, Ms. Camacho. It's really a pleasure to be here with all of you today. On behalf of the World Intellectual Property Organization, WIPO, I'd like to thank the organizer for this brilliant initiative of bringing together a group of experts in mediation and intellectual property and to spread the word about the benefits of using mediation for the resolution of IP disputes anywhere in the world. Here at the Arbitration and Mediation Center at WIPO, we have over 30 years of experience dealing with the resolution of IP dispute by using what we call ADR, or alternative dispute resolution mechanisms. We can only say that we see an increase in the use of these mechanisms. We see a change of culture in terms of the approach to using mediation as an amicable way of resolving disputes, of highlighting the interest of the parties and really going for win-win solutions instead of always having to be in a confrontational space like it could be litigating before the courts. So we celebrate that, and we are very happy to share our experience with all of you today. I will say more in detail in my upcoming presentation. Thank you.
Thank you so much, Leandro Toscano. And now Justice Anderson.
Thank you, Ricky, and good morning to all of the participants. Good morning to the faculty who will be educating us. And most of all, good morning to the participants who are joining us for this event. The CCJ Academy for Law is very pleased to be associated with the CARIPI project in this endeavor. And we recall that this is not the first time we are collaborating with the CARIPI project and with the EU IPO and with WIPO. We have had one or two other seminars, stroke webinars, if you will, on this topic of IP, and we found that they were very beneficial to the audience. Now, this collaboration that we are speaking of this morning between the Academy and CARIPI and WIPO and EU IPO fits very well into the objectives of the Academy, because we are regarded as the educational arm of the Caribbean Court of Justice, which means that our function is to bring to the attention of the public topics of importance, legal topics of interest, which are novel, and which can contribute in some way to Caribbean development. And I think that the IP mediation webinar or seminar fits beautifully into that theme. As we heard earlier, mediation can be a very effective tool for resolving IP disputes. And whereas the region, we are not very large on advanced technology, and we don't boast a whole range of natural resources. What we do have is intellectual creativity and ingenuity. And I believe that if we can leverage that for a benefit, that would redound to the advantage of our societies. Disputes, of course, are likely to arise, and when they do arise, the question is how best can they be resolved? And certainly mediation is one of those means for resolving those disputes. So the Academy looks forward very much to the next 2 days to share with faculty, participants, organizers, the way forward to make sure that we are making the best use of all the tools available for the resolution of our IP disputes. Thank you very much, Ricky.
Thank you so much, Justice Anderson. Mrs. Alexander Maher.
Good morning to all of you. Thank you very much, Ricky Camacho, for moderating this event. Thank you to all the collaborators and partners here in this event, to WIPO, to the Caribbean Court of Justice, all the speakers. Thank you for collaborating here. So I am representing the European Union Intellectual Property Office, and specifically as we are implementing the Caribbean IP and Innovation Project, under which this activity is organized. So many of you might know the project. It's been going on for 2.5 years or so, and there is 1 more year left, or 3 years in total. So yeah, it's a pleasure to collaborate again with some of you as we are tackling different kinds of activities and all kinds of topics. But yeah, today the objective of this event is to provide a discussion forum to exchange best practices in the field of IP, alternative dispute resolution and mediation. So concerning that, criminal prosecution and civil action tends to be lengthy, complex and costly. IP mediation and ADR methods provide a feasible alternative. Their advantages are obviously that they are more cost and time effective. And there's a possibility to tailor them to the needs and the business interests of the parties. So our honorable speakers will shed a light on how mediation unfolds from different perspectives of all parties involved and in the process, and the benefits these methods may bring for the resolution of complex conflicts. During this CARIPI project, we already had a specific session also for judicial representatives on trademark and GI matters. And we are planning a case law conference at the beginning of next year, to be confirmed where. But also we are currently collecting some cases, different stakeholders involved here to uncover cases in the region. So we hope this is these discussions are going to continue. And yeah, I wish you a successful event here and fruitful discussions. Thank you very much.
Thank you so much, Mrs. Alexandra Martin. Thank you to all of the speakers for their introductions. Our first presentation this morning is on the benefits of intellectual property mediation. And our speaker will be Senator Anthony Vera, attorney at law and intellectual property mediator. If I could just give a little background about our first speaker. Mr. Anthony Vera has been practicing law since 1983 with a special interest in intellectual property, telecommunications, entertainment, environmental, corporate, and commercial work. Between 1993 and 1995, he served as the senior Crown Counsel in the Attorney General's Chambers in the British Virgin Islands, where besides advising and litigating on matters involving public law, he is a certified advanced commercial mediator and has been conducting mediations for over 18 years. He was the Law Association's representative on the Mediation Board of Trinidad and Tobago during the period 2010 to 2014. We also know that in the British Virgin Islands, there is the commercial court. And we also know that in our region, courts are becoming more and more specialized, which is really exciting for our area that we work in intellectual property. But I will actually really look forward to this, and really excited to hear from you, Senator Anthony Vera.
Thank you. Good day, everyone, and all protocols observed. So the benefits of mediation in intellectual property disputes. Well, mediation may be described as a structured negotiation where a trained neutral guides the process. The term intellectual property, or IP for short, encompasses trademarks, copyright, patents, registered designs. IP is vital to success in obtaining and maintaining a competitive advantage in any commercial or industrial activity. Small businesses also own IP, and they frequently encounter difficulties with their IP matters, sometimes due to insufficient knowledge or limited resources. But the bottom line is, whether one's business is big or small, one should take IP seriously. IP disputes are essentially property disputes, usually pertaining to someone using or infringing a person's IP without permission. But they can also involve ownership disputes, disputes between employers and employees, disputes between similar brands, which may be causing confusion in the marketplace, and as occurred not so long ago in Trinidad, disputes between collective management organizations regarding copyright and neighboring rights. Further, as contemplated under Section 50 of our Copyright Act, disputes may also arise in relation to the amount of equitable remuneration or compensation payable in respect of the use of a work, sound recording, broadcast, or performance. So, given the potential for disputes at any time, and that proper protection of one's intellectual property can make all the difference between commercial success and failure, it behoves every business which relies on intellectual property to have effective resolution procedures in place. The typical response when someone is found to be infringing IP is for the lawyers of the rights holder to move towards shutting down the infringement as quickly as possible, usually via an injunction, and then pursuing financial claims for damages at a later stage. IP lawyers are always concerned about the importance of not delaying in bringing actions to avoid application of the acquiescence defense. But whatever the background circumstances of the dispute, what the rights owner most wants is for the infringement to stop. And once that happens, for example, in the wake of an interim order which prevents the infringement pending determination of the matter, that may open space and opportunity for the parties to explore the possibility of a negotiated resolution. And especially if the infringement was not intentional or was legitimately accidental. Settlements make sense, given that they may avoid the agony of expensive, protracted, and uncertain trials, and maybe as simple as the issuance of a retrospective license, which can be enshrined in a court order. Besides offering the possibility for an innocent infringer to regularize his position, some other reasons why parties might consider settling without having to go through the full court process include, and I'm going to give these in no particular order of importance, the fact that IP is highly specialized. And unlike the Intellectual Property Enterprise Court in the UK or the boards of appeal in Europe, we have no specialized IP courts in the Caribbean. Further, in Trinidad and Tobago, there are at present, as far as I'm aware, no magistrates and just a handful of judges with training and experience in IP matters. And the same applies with legal practitioners, there being just a few who are IP savvy. Now, one of the drawbacks here is the heavy reliance by members of the public to look to the IP office for guidance and help. However, as part of a government ministry, the IP office must remain neutral and cannot give legal advice to members of the public. Also, most IP offices tend to be understaffed and under-resourced. And IP offices have no enforcement powers, they are not enforcement bodies, and even when they are aware of IP infringements and breaches of the IP legislation. Mediation is something that the IP offices can recommend. It can be of real assistance to members of the public who find themselves embroiled in IP disputes. Another drawback when lawyers litigating IP disputes are not IP savvy is the tendency for more focus to be placed on procedural and technical points rather than on the substantive IP. And it's easy to get derailed on the procedural and technical merits because litigation takes on a life of its own. Yet another drawback is that litigation is a zero-sum game. And even when you win, you can lose. For example, when commercial litigants are constrained to commit energy, time, and resources to pursuing a legal action, it detracts from other more profitable activities, not to discount the stress and the uncertainty involved. Litigation polarizes parties. It's one thing I could tell you, it will destroy relationships. Whereas mediation recognizes that the relationships of the parties is important. Litigation tends to be straitjacketed in terms of pleadings, the law of evidence, and available remedies. And given that the judge's toolbox is limited to strict rights-based remedies, whereas mediation is flexible and can help parties find a sensible and positive outcome to their dispute. Being able to negotiate a mutually acceptable agenda goals, means, and approaches. Being able to choose how you want to solve the problem and being able to secure a more positive and pragmatic relationship are not things to be scoffed at. So, for example, in the case of a trademark dispute, the parties can agree on a coexistence agreement to change a logo or to make adjustments, such as the removal of a word. Litigation can also be a double-edged sword. For example, registered trademark cases are often met with counterclaims that the trademark is invalid. And if the claimant falters in his claim, resulting in the trademark held as invalid, then the loss doesn't just affect the claimant's relationship with the defendant, but every other competitor or potential competitor. Mediation avoids the risk of complete loss of the claimant's trademark or a complete prohibition on use by the defendant. It may offer a new way of seeing a situation and the possibility for change, growth, and optimum solutions. Prosecuting IP disputes can also be logistically challenging, given that the burden of proof is primarily on the claimant. Gathering evidence can be difficult and time-consuming. And it's very rare that you will find a case that is a complete slam dunk. Cases are really black and white. Last but not least, under the overriding objective of our civil proceedings rules, parties are required to negotiate and to at least try to engage in meaningful settlement negotiations. And a failure to do so can result in cost sanctions. Now, of course, what I have said so far assumes an understanding about mediation. And so for those who may not be familiar with the process, allow me just to elaborate. As mentioned at the start, mediation may be described as a structured negotiation where a trained neutral, usually selected by the parties in dispute, will guide the process in helping them reach a negotiated settlement. The following points bear noting. Mediators have no power to adjudicate or to impose awards. Mediators don't investigate or verify information. They cannot order disclosure or the verification of documents. Mediators are not obsessed with questions of fact. Mediators have no authority to impose a solution. Mediators cannot, and we do not, judge, lecture, chastise, punish, or give legal advice. It's not for the mediator to determine who's right, who's wrong. The role and skill of the mediator lies in helping the parties choose a solution that works for both of them. The role of the mediator is to allow the parties to each describe how they see the situation, to guide the parties through the issues, to consider and analyze perspectives, and to see if the parties can reach common understanding and agreement. Good mediators use the art of reframing. Now, reframing doesn't mean that you deny the inherent risks in the situation. Reframing allows you to consider reinterpreting the situation in a way that can help you move through it. Good mediators use questions because nothing shapes our lives like the questions we ask, fail to ask, or never even dream about asking. The mediation process is voluntary. Even when a court compels parties to participate in a mediation, the decision to reach a mutually acceptable agreement is entirely their choice. Mediations are confidential, and they're conducted without prejudice to the legal rights or remedies of the parties. So, unless, of course, they reach an agreement to settle their differences. As I like to say, litigation is the place to make a point. Mediation is the place to make a deal. Now, in the text, representing clients in mediation, the author, Marcus Stone, posits that, and I quote, "The aim of litigation is to reach a correct decision about the respective rights and liabilities of parties in a specific situation. The assumption is that there can only be one correct conclusion, not a range of them. Litigation sacrifices every other consideration. Absolute aim of reaching the correct legal decision by establishing the facts and applying the law to them. Everything else is irrelevant and must be rigorously excluded in court. There is no attempt to solve the parties' business problems, to satisfy their respective interests, or to restore their broken relationship. Commercially beneficial solutions can have no place in the consideration of the court or in the outcome. This is limited to a judgment about legal rights and liabilities, end of quote. On the other hand, the outcome of mediation is in no way a judgment about who is right and who is wrong. It is not a legal judgment in any sense. It is simply an agreement between the parties. Whether this is a good or a bad agreement, it cannot ever be faulted on the ground that it was the incorrect decision of a tribunal. It is simply what the parties agreed to do. Moreover, the subject matter of the agreement is the result of focusing on all these questions of the parties' commercial and personal interests, which the courts ignore. This is the raison d'etre of mediation. It's not a byproduct. The agreement is designed to give effect to these interests. The original legal issues are disposed of by agreement as an incidental matter. Harvard Law School professor Frank Zander pithily distinguishes the two processes by describing mediation as a future-oriented process, while court and litigation are past-oriented processes. Now, having said that, mediation is related to and connected with litigation, indirectly, but with some degree of dependence on it. And although mediation is a voluntary process, it operates in a context where litigation is a potential factor and exerts an influence. All mediation of this nature takes place in the shadow of the court. So what's the court's take on this? Lord Neuberger, master of the rules, has said this about ADR, and I quote, "I believe that there will be many cases where it will be right for parties and their representatives to consider ADR in its various forms. They should do so during the pre-action stages of litigation. They should consider it after proceedings have been issued, and they should continue to consider it while the claim progresses to judgment. It is often said that it is never too late to settle. Equally, in some cases, it may well never be too early to settle. A lot, of course, will depend on the nature of the claim. But in the field of commercial litigation, I can see no good reason why parties should not routinely, in almost all cases, consider adjudication, arbitration, or some form of mediation. I suspect that in many cases, this is already second nature to many commercial lawyers, not least those faced with the type of commercial considerations I outlined earlier. For those to whom it isn't yet second nature, it ought to be," end of quote. So in closing, mediation can offer a speedy resolution and a full spectrum outcome where all factors are considered and addressed, not just the commercial, but even the personal needs of the litigants as well. In mediation, the parties retain control over the procedure and the outcome. And this allows also for confidentiality to be maintained and avoiding the publicity of a court hearing. In mediation, one is not looking to prolong the fights of the past, but to focus on the future and the problems at hand. Mediation is not meant to replace the court in all cases, but it can and it does have advantages over going to court, such as being more flexible, faster, less stressful, and less expensive. So Given the stark contrast between the rich range of negotiated solutions available in mediation as compared to the narrow range of remedies on offer from the courts, it begs the question. It's a pity that such an extremely versatile process remains so underutilized. The courts should always represent the last resort to failed negotiations. I thank you.
Thank you so much, Senator Anthony Vera. And now we will turn to our next speaker. We will focus on the global alternative dispute resolution ADR context with a presentation on WIPO IP, intellectual property IP mediation services by Mr. Leandro Toscano, who is the head business development unit, WIPO Arbitration and Mediation Center. If I could just say a few brief words about Mr. Leandro Toscano. Mr. Leandro Toscano is the head of the Business Development Unit of the World Intellectual Property Organization, Arbitration and Mediation Center in Geneva, Switzerland. He holds a law degree from the University of Buenos Aires and an LLM in International Dispute Resolution from the University of London, Queen Mary University, and the University of College London, and a specialization in intellectual property and information technology law from the Catholic University of Argentina. Leandro was the WIPO Center's representative in Singapore from 2011 until mid-2014, before joining the World Intellectual Property Organization in 2008. He was in private practice in intellectual property and information technology law. I will now turn over to Mr. Leandro Toscano.
Thank you, Ricky, and thank you to Senator Vieira for the excellent presentation and description of the advantages of using mediation. I think it was very clear and picture all the different opportunities that parties can benefit from when using mediation to resolve IP disputes. In my short presentation today, my idea is to show you a bit about the experience of the World Intellectual Property Organization when it comes to cases, the type of cases, type of disputes, type of solutions, and trends that we observe, I would say at an international and global way, and also to describe some of the collaborations with different government institutions in different member states, sort of menu of ways in which the public authorities can contribute to promoting and to the use also of mediation for IP disputes. So first of all, of course, most of you might be familiar with WIPO, World Intellectual Property Organization, this UN agency that specializes in IP and leads the development of the global IP system to promote creativity and innovation. So WIPO has different functions, and it has 193 member states, and of course all the member states are represented in this meeting today. And apart from the work that is done with the countries in terms of assisting in developing the IP system, also acting as a forum for the negotiation of international treaties, for example, WIPO provides services that are very much used by the different actors in the IP ecosystem. And within the services, we include there the dispute resolution services, or ADR, alternative dispute resolution. This is happening in a sector that is named the IP and innovation ecosystem sector. The idea is to support enterprises, and here we're talking about multinationals, SMEs, startups, enterprises also as creators, innovators, entrepreneurs, in the commercialization and the use of IP for business growth. And of course, disputes can very much impact businesses when they occur, and this is why we are located in this sector, and we also work across the organization with the different colleagues in different areas to implement programs, to raise awareness, and to provide services to the stakeholders. So here at the Arbitration and Mediation Center, we always say that it's not us the ones resolving the disputes, but we have a group of experts that come from different parts of the world, I would say we have a list of about 2,000 experts with expertise in different areas, trademarks, patents, copyright, software, nowadays more and more the digital environment, e-commerce. These experts are appointed as arbitrators or mediators depending on the cases. One of the big advantages of using an international organization for international disputes is neutrality. So sometimes inviting another party to, could be to the courts or to a mediation or an arbitration in your local country can become an obstacle for the other party to accept, as there could be some perception of not, the home court advantage in a way. So here we see lots of cases that involve parties coming from different regions from around the world. And our experts, of course, know about IP, but they are, of course, they train in mediation, arbitration, and other dispute resolution mechanisms. So the idea is to try to find in every dispute the most suitable candidates that the parties can then select for their particular case. This is when we are adding value by having this list of experts that parties can choose, and perhaps when going to the courts, they may not have that chance. Now, if we look at some numbers of the WIPO ADR case law, we can see that disputes in the different areas of IP, including patents, trademarks, copyrights, they're more or less even. We've seen an increase in copyright disputes in the last few years, and this is very much linked to the, let's say, the easiness of using digital works throughout the internet, and this could be streaming of music, for example, the use of audiovisual in social media. We have ebooks, we have anything related to mobile applications, and nowadays we are seeing some cases related to disputes happening in the metaverse or related to non-fungible tokens or NFTs. In terms of the source of these disputes, we have seen a very important increase in non-contractual matters. So here we're looking mainly at infringements, so situations when a party invites the other, let's say the IP right holder invites an infringer, a potential infringer, to consider mediation instead of going to the courts, or in some situations while they're in the courts, asking the judge to suspend the case for a certain period of time and to refer the matter to WIPO mediation. So this is why we see an increase in these non-contractual cases, as opposed to the more traditional way of referring disputes to ADR, which is by including clauses in your contracts, in your IP contracts, your licensing agreements, your assignment agreements, your co-production agreements, your software maintenance or development agreements, etc., etc. In terms of domestic and international, so I mentioned already that WIPO is a neutral international institution. So here we see that around 70% of the cases that are referred involve parties from different jurisdictions. And of course, IP has become more and more international. There are more collaborations from parties coming from different jurisdictions to both to create and to use IP. So that, of course, leads to more international disputes and perhaps the need of using this sort of mechanisms instead of the traditional court litigation system. If we look at the settlement rates in mediation, we can see that 70% of mediations that have been referred to WIPO historically end up in a settlement agreement. That's a very high percentage. Also in arbitration, and I know it's not today's topic, but it's important to highlight, in more than 30% of the arbitrations that we administer, the parties end up reaching an agreement before the arbitrator issues an award. So the conclusion here is that in intellectual property dispute, there's a lot of room for settlement, for negotiating, and for reaching win-win solutions. At least this is what we see from the data collected in our cases. With regards to the location of the parties, when the center started back in the early 90s, we could see that the services were mainly used by international and multinational companies based in developed countries, so looking at North America and Europe mainly. And in the last few years, we have seen an increase in regions like Asia and Latin America and the Caribbean. So that's very encouraging as we continue working with the different partners, for example, IP and copyright offices, to promote the use of mediation and arbitration. Then we also see an increase in the use of these mechanisms. We can also mention that since the pandemic, and perhaps this is one of the few things that we could say that were positive about the pandemic, is that everybody got used to being on Zoom meetings and online video conferences. So that also applies nowadays to the administration of cases. I would say that more than 90% of the cases that we currently administer are happening in the online environment. And this could be done through different platforms, so that it depends a lot on the party's needs. But I think what it's important to highlight is that party seems to be a lot more keen than in the past to use this option, and that's very much benefits smaller players in the system that perhaps in the past wouldn't be able to travel and to allocate time and money to travel to a mediation meeting or to an arbitration hearing. And nowadays this could be done for free by using any of these platforms. We have noticed also an increase in the number of cases received here at the center. Last year, we saw over 100% of increase. And this is very much linked to collaboration with IP offices in some member states. And I will present these collaborations for you to have as an example of a successful implementation of ADR programs with the assistance of the public sector. In terms of WIPO mediation, so very easily, it's like any other mediation. There are a few things to highlight, and perhaps I would start by mentioning that a WIPO mediation can be initiated by any party if there's a prior agreement, or if there's a clause in a contract that any party or the parties jointly can start the mediation process. But in cases where there's no agreement, maybe there's a contract but there's no WIPO mediation clause, or perhaps there's no contract in infringement cases, any party can invite the other one to consider mediation. And as Senator Vieira mentioned, of course, this is consensual, so parties need to agree to participate in the process, so we cannot force anyone to participate. But at least it's, if you invite someone to consider mediation, you are showing your goodwill to participate in this amicable procedure instead of going straight to the courts. Now, some of the developments that we have observed, we can mention the growing acceptance. This is very much linked to the increase in the number of cases that we see coming to WIPO. We also see that companies, they are more comfortable with making it publicly available, that they are willing to participate in mediation procedures, for example, and this could be by signing mediation pledges. Then the use of multi-tier dispute resolution clauses in contract is also quite interesting. Here, I would say that between 30 and 40% of the contractual cases that we receive at WIPO include an escalation clause, a multi-tier dispute resolution clause. So mediation followed by arbitration, or mediation followed by core litigation. So in many cases, the dispute does not escalate to arbitration because parties manage to resolve the matter in the mediation phase. So by including mediation, where we say that you don't lose anything, you just give an opportunity. And in some instances, perhaps the parties cannot manage to resolve the whole dispute in the mediation phase, but they manage to narrow the dispute down and then focus on the particular matters in the course of an arbitration or court litigation. The use of technology, I already mentioned, is increase in the use of video conferencing facilities and online case administration platforms. In terms of legislation, we can highlight a few examples at the national, regional, and international level. So at the national level, we see more copyright laws and trademark laws, including references to mediation, to copyright tribunals, the possibility of resolving disputes out of court. In terms of regional legislation, for example, in the European Union, we can see the directive on the digital single market and the regulation of the Digital Service Act that both include a few references to specific situations where mediation or other ADR mechanisms can play a role in resolving disputes in the digital environment. At an international level, we can mention the recently launched convention, the Singapore Convention on Mediation, which is also a very important development. Other institutions, some of the institutions like some copyright offices provide mediation incentives or promotion schemes. I will mention some when I cover the examples. So if we look at the work that WIPO has been doing, I would say in the last 10 years with member states, with different countries, we can highlight some successful collaborations. And I would like to start here with a collaboration with the Trinidad and Tobago Intellectual Property Office. Yeah, it's also a good opportunity to highlight the work of Mr. Regan Asgarali and his team there in promoting ADR, not only in Trinidad, but also in the region. So here we entered into a collaboration agreement a few years ago, and we started by providing different training. We provided training to some neutrals, and now we have a list of neutrals, including Senator Vieira. I also see that among the participants, I see Jason Charles is there. So all these experts that are, an opportunity they have, they promote mediation for IP among their clients or contacts or other institutions. And they are, for WIPO, our local partners that, of course, we are here in Geneva. So it's very important to know the local needs, to understand the local practices. And for that, the mediators based, in this case, in Trinidad and Tobago, are the best example. So we work together with the office and with the experts to shape the process, to make it available. And the intention is to make it as easy as possible for anyone to approach the office, to approach WIPO, and to find out more about how to resolve disputes by using these mechanisms. Another example is a collaboration with the Intellectual Property Office of Singapore, IPOS. This is a collaboration that started back in 2011, where we entered into an agreement to develop a mediation system, in principle focus on trademark opposition proceedings. So whenever there's someone filing for a trademark before the IP Office of Singapore and there's an opposition, then the office invites the parties to consider the possibility of using mediation. And for that, they can use WIPO, and there are other local providers too. So for that, we train a group of trademark lawyers, experts in Singapore and the regional law in ASEAN countries, because many times the disputes involve other disputes that are happening in the region too. And we built this list of mediators, and with the list of mediators, then we started providing the service. What happens in practice is that any party in the opposition procedure can invite the other one to consider mediation, and if the other party agrees, they can agree on suspension of the administrative adjudication procedure before the office. And if they reach an agreement, that's the end of the dispute. And if they cannot reach an agreement, then they go back to the administrative track and they continue until the office issues a decision. Another example in the area of copyright is a collaboration with the Ministry of Culture, Sports and Tourism of the Republic of Korea. So the MCST has established funds and trust here at WIPO to promote the use of mediation for copyright and content disputes. And as you may know, Korea is a very important supplier of content to the world. It could be by music, by K-pop, and we know about Korean movies and video games and esports, for example. So it's very much in their interest to promote the use of these mechanisms to reduce the impact of disputes in the creative industries in Korea. So with that, we have created a mediation promotion scheme. So with the funds provided by the Ministry of Culture of Korea, certain number of cases are supported throughout the year, and part of the cost is funded. So then it's easier for any party to use the mediation scheme. Another example is a collaboration with courts in China. So here, there's a collaboration with the Supreme Court of China and certain IP tribunals in different regions, in Shanghai, for example, that whenever there's a case that involves a Chinese party and a foreign party related to IP, then the judges can suggest parties to go to WIPO mediation. And so far, we have seen over 60 cases coming from this source. The service is now being extended to other provinces in China due to its success. So it's another tool, right? It's not going to solve it. Not all cases will be referred to mediation, but in some instances, it's a way for the courts to refer these matters to a specialized ADR provider. So that's a very interesting collaboration, and there are other countries that are looking into this possibility too. In terms of conciliation, which, conciliation and mediation are similar terms. In this case, conciliation for copyright disputes in both Mexico and Colombia is done by the copyright offices. So by law, they have the possibility of providing this service. So any party can file a conciliation request with the Mexican or Colombian Copyright Office, and then the office will call the parties to a conciliation meeting that will be conducted by staff of the office. So this model is a bit different. Here we're not looking at external mediators or conciliators, but we're looking at staff of the office that has been trained to provide conciliation services. The issue here was that these systems were in place, and during COVID, because there was a requirement to be present in person for meetings, both in Mexico City and in Bogota in the case of Colombia, which was already a bit of an obstacle for parties that were not located in Mexico City or Bogota, because they had to travel for a conciliation meeting to the city, to the offices of the Copyright Office. In some cases, disputes are quite small and not too complex. So, it was probably not so easy to get there physically. So during COVID, with the restrictions, it was not possible for anyone to meet in person. So there we assisted here from WIPO, based on our experience in conducting online mediation and arbitration. We assisted these two countries, and we provide, we develop a platform, and we have video conferencing services that these offices can use. Thanks to that, now in Colombia, 100% of the cases are being conducted online. And in Mexico, still some parties prefer to use the in-person meetings. But the interesting part is that traditionally you have about 30% of attendance rate. So that means that at least one of the parties was present in the meeting, but not both. And since we implemented this video conferencing system, the attendance rate has raised to more than 95%. So that means that parties are finding it very useful to just click and connect and participate in meetings rather than having to move physically, especially in big cities where, it could take a long time to get to places. So that's been a very successful implementation, and we are now working with other countries like Guatemala and Paraguay to implement similar services. I know I'm running out of time, so I apologize for that. I will just take another 2 minutes to finish with my my presentation. Here are some resources that you can explore. So we have this different for example, publications where you can see how WIPO mediation works, and some case examples. And there's another initiative that I also wanted to mention, which is the WIPO Mediation Pledge for IP and Technology Disputes. So that's an initiative that we started a few years ago. And the intention is to promote the use of mediation. And of course, this is not not binding, and there are no legal obligations. It's just simply joining the pledge to express the intention of considering mediation, for example, when drafting IP contracts, clauses in IP contracts, or whenever advising a client, at least to have mediation in mind. And again, this doesn't have any legal obligation. This initiative is supported by more than 35 institutions, including IP offices like the Trinidad and Tobago Intellectual Property Office, among others. So it's an initiative that helps a lot to spread the word about mediation. And then to conclude, I just wanted to highlight a new service that we have been providing in the last couple of months, and this is what we call orientation sessions. So these are one-to-one meetings that anyone can have with our staff. So if there's anyone interested, you can scan the QR code, book a session in the available times in this virtual calendar. This is very much used by parties that are, and lawyers too, that are involved in disputes, and they may want to know more about if their dispute would be suitable to be referred to mediation. Of course, we cannot provide any legal advice, but we will guide them in terms of how mediation can be used, how WIPO mediation can be used in that particular matter. With this, I'm concluding my, say, more formal presentation, but of course, I'm happy to engage in any discussions and questions at the end of the day. Thank you very much.
Thank you so much, Mr. Toscano. That was a very informative presentation. I see already we have some questions. It was very interesting, particularly to learn about the new service being offered about booking an appointment. I think that many people will, do that. And it's great to know about new initiatives, and I thank you again. At this point in time, we're going to move to our next speaker, which is Mr. Goran Marjanovic from the EU IPO, and he will be speaking about, he will focus on EU IPO IP mediation services. Just a little bit about Goran. Goran holds a position on the EU IPO, the European Union Intellectual Property Office's Board of Appeal, Alternative Dispute Resolution Service, and is an accredited mediator. He has over 10 years of experience at the EU IPO dealing with legal matters, litigation, international cooperation, and institutional relations. Goran was previously employed as a lawyer in an international IP law firm and in legal affairs at the European Commission. Goran is specialized in EU and international IP law, as well as institutional relations and cooperation. Recently, Goran joined the ADR service at the EU IPO's Board of Appeal, where he has begun working on the creation of a mediation center at the EU IPO. And we'll now turn over to him. Thank you so much.
Thank you very much, Ricky. It's a great pleasure to be here. So hello to everyone. I guess it's good morning still in your side of the world. So good morning to everyone who's connected. Also, before I get started, while I load my presentation, I think it should be starting now. I would like to congratulate Senator Vieira and Mr. Toscano on their excellent presentations. I think very impressive services offered by the WIPO when it comes to ADR, and particularly on the statistics, they're beyond encouraging. So great work there. I hope you all see my PPT now. Is it okay? Yes, thank you. So we'll get going. Another thank you to Senator Vieira here, because I think you, in a much more emphatic way, described what we consider at the EU IPO as the main features of our ADR services. So one thing that where I'm going to probably break away from the rest is that they are limited to proceedings before our office, and even more limited mainly to appeals, but we'll get to that later. But indeed, as As presented earlier, they're voluntary, flexible, fully confidential, time efficient. This with an asterisk, if the parties wish for it to be time efficient, they can also drag on. It really depends on the motivation of the parties, because at the end they are in the driving seat, which I believe Senator Vieira really emphasized as well. So we can do them online, we can do them in person. We have some flexibility as to the platforms, but we are limited to EU data protection rules. So it cannot be on just about any platform. I think one thing that sets us out is a bit that we do not have any additional administrative charges involved with the mediation services, for instance. However, we are limited to those proceedings that we're handling directly. We do have a number of languages that we operate under, which I think is helpful within the EU context, but also internationally. And we found that it's most effective when there's complex disputes with I think this was also described by Senator Vieira, where there's cross appeals, multiple national proceedings, and when you can achieve one global solution to cover them all, it's hard to say no to that. Finally, our mediators are all internal mediators. They're EU IPO staff experienced in IP law and also trained in mediation. So this is kind of what I mentioned earlier. It's we're limited, obviously, to inter partes proceedings. As an IP office, the office does issue decisions to single parties when it comes to absolute grounds. So, for instance, on trademark applications, these cannot be mediated. But basically any other type of inter partes proceeding can be, provided that it's now at second instance. This is for the moment, but I'm going to tell you a bit more about how we're planning on changing this in the short term. And we did during COVID, which was also mentioned by Mr. Toscano, we did offer a special service to small and medium enterprises, which gave them the opportunity to request mediation at first instance. And we had some success there. Now, obviously, as we go back to the point of voluntariness, it really very much depended on the acceptance of the counterparty, which tended to be the opponent in opposition proceedings. So it depends on their willingness to negotiate, naturally, but yeah. That's the current state of affairs. And I thought also it might be useful because we conciliation has come up as well in the Colombia and Mexico copyright context. But we do offer conciliations and we do offer expert determination. So I've kind of thought I'd shed a bit of light on them in addition to mediation, which is of course a focal point today. So mediation, I won't spend too much time on again, because it's been very nicely described already. The only thing I'd like to say that maybe we do somewhat differently is that we do allow for the possibilities for the parties to invite their mediator to be more evaluative on those areas of expertise. But this is naturally only when it's explicitly requested by the parties and only when the mediator feels that they can do so in a constructive manner. This would make it more akin to a conciliation, nevertheless still within the process of a mediation. The conciliation itself is that the person handling the case, which at the appeal stage is known as the rapporteur of the appeal, proposes solutions to the parties involved in this appeal. And now the parties can basically choose to reject the solution, which means that the formal proceedings litigation resumes, or they can agree to consider the solutions and even further negotiate them, further to find further precision on what they're willing to agree on, or they can ask for a mediation. So basically stop the formal proceedings, and move on with a third party neutral that would guide them through the full mediation process. And then finally, we have a little used service, and it's actually a sort of add-on service to the mediation process. It is not really possible to request a standalone expert determination. However, within a mediation, if the parties and the mediator find that there is a technical obstacle in the way, they may propose or wish to opt for an expert determination on a very concrete, specific technical topic, in which case, basically the parties would deal with another third party neutral that's an expert in the area of the obstacle, who would then give them a mainly non-binding determination or opinion on that matter, and then hopefully that could resolve at least the obstacle so that they can move ahead in the mediation process itself. How it works in simple terms at the EU IPO, we have 2 entry points for a mediation. It can be requested by the parties to an existing dispute before the EU IPO Boards of Appeal. Can also be proposed by the rapporteur, and then provided that the parties agree to attempt mediation, they would then select a mediator. The mediator would contact them to sign the mediation agreement and ask some initial questions before proceeding to the actual mediation meeting, in which they use a combination of joint and individual sessions to move forward and hopefully find a settlement agreement. Now, we've noticed that in the online setting, which Mr. Toscano has also touched on, there's no longer such a thing as a mediation day per se. They tend to drag over multiple sessions, but we found that somehow it seems to work better for the parties because they don't have to make such a big time investment on one particular day. And so that's a bit of, let's say, a trend that's emerging from the online environment that maybe wasn't present when everything was physical. But yes, indeed, it seems very similar also to the workflow that Mr. Toscano presented at WIPO. And now we like to always consider what are the roles of the different actors within a mediation. I think I mentioned that the parties are in the driving seat. So really it's the parties that decide on the outcome, whether it will be positive or negative. And they also have to agree and commit on whatever follow-up actions need to be taken. As we are an IP office, perhaps there need to be other formal and administrative steps to be taken, such as limitations of goods and services or withdrawals. So it's really all up to the parties. The lawyers, I think by far they're the most important in the drafting of the settlement agreement because they know how to express the aspects of the agreement in legal terms in writing. And they, of course, need to verify the legality of what's in the settlement agreement because the UIPO does not actually have any liability over the legality of the settlement agreement. And the mediator in the settlement phase can ensure that all of the aspects agreed upon during the mediation are included, so nothing's been left out or insufficiently addressed, but again, will not be in any way involved in any enforceability or liability concerning the agreement itself. And now our mediators, when they're finished, to the extent that they may have received any documentation throughout the process, they do destroy all of it. The only thing that is retained in a confidential online storage is the mediation agreement itself. And we also do love to have feedback on how the parties experience their mediation. So we do send out a satisfaction survey. Naturally, settlement means that eventually in the short term, the formal proceedings would be withdrawn. And if there is no settlement, the suspension is lifted, the formal proceedings resume, which basically means that a decision is prepared and notified to the parties. Now, the big changes, well, we're in the process of some very big changes, and basically it's a program consisting of 4 projects that's under the new Boards of Appeal Action Plan. The 4 projects basically aim to establish a mediation center, which is the focus on project 1. The second project is really focusing more on the digital environment that can support the offering of mediation center services. This again, I think Mr. Toscano mentioned the EADR that's available at WIPO. We're trying to develop a platform that can also help us and the parties and the mediators get through a mediation process in the most effective manner. We do also continue looking into stakeholder engagement and further cooperation. So indeed, WIPO, we have a relatively frequent meeting with, and WIPO is also on our stakeholder advisory board, which tries to give us insights and help on the way forward on how we can improve our services. So again, grateful to WIPO for that. And then internally, we have to increase our capacity because I guess we're bracing for greater demand in these services. So we're in the process of training more mediators. And this kind of comes along with making sure that our users, IP system users within the EU and abroad, are aware of the fact that they can avail of mediation services for free when they find themselves in a conflict before the EU IPO. So this is very exciting right now, and yeah, a lot of work ahead in the short to medium term as far as that's concerned. This slide basically just tries to go a bit further that, of course, a mediation center needs an operational infrastructure. We will expand to all of the inter partes proceedings before the office, including first instance, so it will no longer be limited to appeals. I think Senator Vieira said it's never too late, but it's never too early either. We're going to try the earlier one now because we were doing the later one up till now. So thanks for that great idea. More mediators, more EU languages. Right now we can handle about 14 EU languages, but we're going to work on continuing to increase that. Platform I've mentioned, and awareness raising as well. So finally, yes, you can try to find us online. I think easier than the hyperlink, just Google EU IPO ADR or EU IPO mediation. You'll find us. There's a bunch of information there that you can explore. And of course, if you have any questions concerning that, then you just get in touch with the email address indicated there. It's also available on the website, and we'll be happy to get back to any questions you might have. So that's it from me. I thank you all very much for your attention. And likewise, if there's time in the discussion later on, I'd be happy to answer any questions. Thanks.
Thank you so much, Mr. Goran Marjevic, for sharing with us the EU IPO's IP mediation services. You can see a lot of exciting developments. And now we're going to turn to our next speaker. Our next speaker is Justice Winston Anderson of the Caribbean Court of Justice, CCJ Academy for Law, who will speak on the rules regional court provides for alternative dispute resolution and cross-border resolution. If I could just say a brief few words about the Honorable Mr. Justice Winston Anderson. He is of Jamaican origin and upbringing. He took the degree of Bachelor of Law from the University of the West Indies in 1983, and in 1988 graduated with a graduated with a doctorate of philosophy from Cambridge University. Also, in 1988, he was called to the Bar of England and Wales and later to the Bar of Barbados and Jamaica. He was professor of law at the University of the West Indies for 22 years, executive director of the Caribbean Law Institute Center and the general counsel of the Caribbean Community. Professor Anderson was elevated to the bench of the Caribbean Court of Justice, the CCJ, in 2010 and became the founding chairman of the CCJ Academy for Law. Justice Anderson is a member of several global organizations related primarily to international law, environment, and sport. He is also author of numerous articles in referred journals and of several leading texts. I now turn you over to the Honorable Justice Winston Anderson.
Thank you very much, Ricky. It's a pleasure to be with you once again. And I must say thank you very much to those speakers who have preceded me. I think they've made a very solid, excellent foundation for my very short presentation. I noted, of course, that the first speaker spoke about the advantages and the features of mediation in very clear, eloquent terms, of course, as is usual for him. And then the other two speakers spoke about operational aspects of resolving IP disputes in their various regions in terms of the WIPO Center and then, of course, the EU IPO. I'm speaking now about the situation in the Caribbean. And generally speaking, I'm aware that there are attempts to stand up certain arbitration centers in some of our jurisdictions. I'm not very au fait with what is happening within those arbitration centers. And I'm sure within the audience, there are persons who can speak more definitively to that situation. So my focus is much more general. And I want to speak about the opportunities primarily that are available for parties to settle their IP disputes through the mediation channel. As we heard earlier, of course, mediation is one of the more popular tools in the ADR arsenal for the settlement of disputes. The mediation involves consensual arrangement for the settlement of the dispute and hopefully an early settlement of the dispute, so that immediately there are several advantages to going the route of mediation. Of course, these were elaborated much more in the first speech that we had. What I want to mention, and to sort of spend a minute elaborating on, is that as far as I'm aware, as far as research goes, there has been very limited use of mediation in the Caribbean region to settle IP disputes. As I said, I speak subject to those who are working in the various arbitration centers which have been stood up. But as far as general knowledge goes, there is just a dearth of information about any attempt to settle IP disputes by mediation. Therefore, that is why the preceding presentations were so very helpful in sensitizing the audience to the possibilities that exist. Limited use of mediation, notwithstanding what I would contend is a fairly enabling environment for the settlement of IP disputes by this method. And I can't go into the kind of constraining factors that were going into earlier, but I could sort of mention maybe on the line one or two that were discussed at the start of this morning's session. So there was a recent study made of IP cases, the whole range of intellectual property related cases across the region, except for Jamaica, because the study was intended for judgments to be uploaded to the WIPO Lex database. And Jamaica had already gone through that process, had its judgments uploaded, and therefore this survey did not focus on Jamaica, but focused basically on all the other members, English-speaking members of the CARIFORUM region. So you'll see here that in relation to Antigua and Barbuda, there were 6 judgments that were researched, Bahamas 16, and so on, Grenada 1, And Trinidad and Tobago, of course, naturally, I would assume, had a lion's share of 35 judgments that were researched, and most of them, of course, were uploaded to the WIPO Lex database. The point I wish to indicate is that, again, from the research and the researcher, there was zero attempt to settle any of these disputes through the means of mediation. That is, I thought, surprising. I'm not quite sure what the situation is in Jamaica. We might come to that in a little bit from now. And again, there are others on the call who are more knowledgeable, perhaps, in this. But there's, of course, a mandatory requirement for recourse to ADR in Jamaica. So the Jamaican situation might represent some change. But in relation to the other jurisdictions, as far as we are aware, no attempt in the 80 cases that were researched for settlement through the means of mediation. Notwithstanding that, as I said, I believe that there is an enabling environment for settlement by this non-judicial route. I was very interested to hear, I think it's Mr. Leandro, who made the point that in some substantive IP legislation, I think he mentioned copyright legislation, there might be a provision for settlement by ADR methods. My own research has not found such a provision in Caribbean legislation. Again, the research is not by any means exhaustive, so that I'm happy to be contradicted by somebody in the audience who knows otherwise. But all of the IP legislation I've looked at, I see nothing in them referencing settlement by mediation. It is true, as was said, that there is often a tribunal which is established under substantive IP legislation. So, for example, under the Copyright Act, there is a copyright tribunal. But that tribunal, when you look at the composition of the tribunal, when you look at its functions, it has really nothing to do with settlement by ADR. You know, it's more part of the regulatory system employed by the substantive legislation. So it does things like issue licensing for use of protected works, helps to set rates for the use of works and so on, but nothing to do with settlement by non-judicial means. I think that the enabling environment is really set largely by the rules of court, and to some extent, more limited way by the revised Treaty of Chaguaramas and the rules of the Caribbean Court of Justice. So just to take you on a short journey, because again, I've not been exhaustive of all of the countries in the region, but in relation, for example, to the OECS, you'll see there that the Civil Procedure Rules of 2000 make provision for mediation. And mediation is possible before or after litigation proceedings, as we have heard, can be initiated by the parties or on the court's own motion. But again, this is a consensual process. It's subject to the agreement of the parties. And there is, of course, a connection, as we heard, between mediation and litigation. Once the parties have, in fact, agreed to a settlement of the dispute by mediation, that agreement is often then embodied in a court order. So we call it a court-annexed mediation order, if you will. And that mediation order then is binding. And there have been circumstances where parties have been referred to mediation, or they have voluntarily chosen mediation. They have gone through the process and they've arrived at a settlement, and then later on sought to backtrack on that settlement, and the court have refused. The court has said, no, you have made an agreement. The agreement has been embodied in a court order, and therefore you are bound by the agreement. And no doubt that would stand the same test if the parties were involved in an IP situation. Of course, as you see here, the cases I've cited have nothing really to do with IP. These are cases from other areas of legal interest. Jamaica does have a mandatory system of court referral in respect of active civil jurisdiction cases, which are not included in specific stated exceptions. And as far as I'm aware, IP cases are not in those exceptions, which means, of course, that there is a mandatory requirement to refer cases, disputes to mediation. As we heard, of course, you can force the horse to the water, but you can't compel the horse to drink. So that even though you send the parties to mediation, you order them to mediation, in fact, there's no compulsion for them to agree on a mediation. Once they agree, of course, as I said earlier, the court can enforce the agreement. If they don't agree, then of course there's nothing to enforce. And sometimes there is sort of an agreement in principle, but not all of the issues have been resolved. There is no settled formal agreement. And in that case, the court obviously will not be able to make an enforcement order there. And that was the case in the court in Green and the Kingsley Stewart case of 2014, when there was an agreement on counsel's brief, but that was not held to be a formally binding agreement. And of course, even in Jamaica, mediation can be dispensed with for good and sufficient reasons. And if there's a strong public interest in having the matter litigated, then the court might choose not to refer the matter to litigation. There's one case on professional misconduct where it was several. This was a case which involved significant public interest, and therefore we were not going to go to mediation. Similarly, environment in Belize encourages mediation under the Supreme Court rules there. The court can refer the parties to mediation. And these are the factors that the court would consider. Many of these, of course, were said earlier. In other words, the nature of the dispute, given that one wants to maintain a kind of cordial, business-like, win-win relationship between the parties. That's a situation which would be suggestive of mediation. Willingness of the parties to participate, obviously, opportunities for joint gains or other criteria considered relevant by the judge. Similarly, in Guyana, mediation can be referred in terms of the possible benefits, in terms of how far apart the parties are, how firmly entrenched in their positions they are, the costs of mediation relative to the value of the claim. Some public policy matters may be inappropriate for mediation, mentioned that earlier. Other relevant criteria considered by the court. Now, Trinidad and Tobago, I won't say very much about this because there are so many on this call who know much more than I do about the situation in Trinidad and Tobago. But what I think is noteworthy is that there is a requirement that parties express in their pre-action letters the consideration of resolving their dispute by mediation. And if they do not express that they have not indicated a consideration of resolving their dispute in this way, then that can have quite serious effects on the further prosecution of their case. The claim can be struck out. And that's a very extreme remedy. The normal remedy is that there would be an award in cost. And the two cases I've cited in the list there suggest that the normal remedy is where the pre-action protocol letters did not, in fact, refer to the possibility of ADR, then the the court might impose costs against the party in default. And this is a serious point. That last case thing, which went up to the Privy Council actually reversed the Court of Appeal's decision not to award costs to the party who was innocent in this case. Mediation Act of Trinidad and Tobago also, of course, provides for the commencement of mediation for a judge in litigation proceedings. And I'm sure we have heard about, and we'll hear much more about, the MOU between WIPO and Trinidad and Tobago on mediation IP disputes settlement. I mentioned earlier that there are arbitration mediation centers around the region. I don't have, unfortunately, an inside view as to what is happening within these centers. I hope, as I said, we'll be getting some enlightenment from some of the persons here. But I gather there is arbitration mediation court in Barbados, Jamaica. There is the International Arbitration Center, and then there are 3 institutions in Trinidad which are worth mentioning: the Caribbean Institute for Conflict Resolution, Conflict Resolution Mediation Center, and then the WIPO Arbitration and Mediation Center that we heard so much about earlier. I would also contend that the revised Treaty of Chaguaramas also provides an enabling environment for ADR. Article 223 of the treaty provides that member states are encouraged to facilitate ADR of private commercial disputes. ADR naturally would fit very, IP disputes would fit very naturally in that category. The original jurisdiction rules of the CCJ encourage the use of ADR, and they do so expressly. So, for example, in Part 8.1(u), the court is allowed to refer any specific issue to mediation. So that power can be used in the way that we have been discussing. There was a use by the CCJ, no less, of mediation in one of the cases that came to us, the Marshall E. Cook case from Barbados, just a couple of years ago. And we thought that that case, unfortunately, again, perhaps something about an IP, but it illustrates the point, that case could have been resolved by mediation. And we consulted the parties were willing to try mediation. And in fact, a mediator from Trinidad and Tobago was appointed, and the mediator did a great job in shepherding, if you will, the parties towards a mutually acceptable solution to the dispute. So that if you look at the record of the court, all that you will see is that it was ordered that the proceedings be stayed on terms agreed by the parties in this mediated settlement. So the opportunities for mediation then exist not just at the High Court or even the Court of Appeal, but at the apex court. We treasure the value and the importance of mediation. I was hoping to share one further slide with you, which spoke about the constraints to mediation possibly. I won't go into this because I thought the first speaker covered these extremely well. But just to say that the culture and tradition in the region may not be supportive of mediation. Lawyers are accustomed to go to court and using procedural and other means to get advantage of their clients. So that is a concerning factor. There are some aspects of IP which involve a criminal element, of course, and that would not be suitable for mediation, clearly. Cross-border dimension, that where there are difficulties, dispute between persons from different jurisdictions, that might also be an obstacle certainly to the court-connected mediation, possibly. But then these centers, which are emerging, are probably quite unrelated to a particular jurisdiction in terms of the origin of the dispute, and therefore could handle cross-border disputes. Relatively small pool of mediators. I think, I don't know the numbers, but I rather suspect that we could have more mediators or lawyers trained in mediation, even though that is not their specialty. And finally, the sensitization and awareness campaign. This is what this morning and tomorrow are about. That is to say, to raise the level of awareness and sensitization of the advantages of using mediation. And that perhaps could also help with having an increase in the numbers of mediated settlements. Well, thank you very much, and I look forward to the question and answer session.
Thank you so much, Justice Anderson, on presenting on the rules regional courts provides for ADR and cross-border resolution. I do believe that the culture is changing, and perhaps more and more we'll see more mediators growing. And I look forward to, under your guidance, more sensitization and awareness in this area in our region in time. So our final speaker for this session is Mr. Kavesh Seethal, who will present on the Trinidad and Tobago IPO ADR Center. If I could just share briefly about Mr. Kavesh Seethal. Mr. Kavesh Seethal has an LLB and is a PhD candidate and attorney at law since 2011. He is currently the Deputy Controller of the Intellectual Property Office, Ministry of Attorney General and Legal Affairs in Trinidad and Tobago, having had years of experience in both the private and public sector. He is passionate about issues of social justice and helping those who are marginalized in society. Currently, Kavesh is pursuing his PhD at Alpha Crucis College in Australia, researching contemporary methods of poverty alleviation. I now introduce to you my colleague, Mr. Kavesh Seethal.
Thank you, Chair, and I hope that you can hear me clearly. And hi, everyone. I bring you warm greetings from Trinidad and Tobago. I know many of us are in the Caribbean, so we feel those warm greetings. All protocols being observed, I just want to say thank you to the CARIPI team, in particular Alexandra and Mariana, for all of their support throughout all of these projects that we have been on. It is a privilege to share this platform with great minds like Justice Anderson and Senator Vera, Mr. Toscano from WIPO, and Goran from the EU IPO. So without further ado, I have to hold up the rear and I have to follow Justice Anderson. I don't know if I can really follow Justice Anderson. He is one of the most brilliant minds that our region has ever put out. So, but I'll try my best. Technical difficulties aside, thank you very much. And I'm Kavesh Seethal. I'm the Deputy Controller of the Intellectual Property Office, and I will be speaking shortly today about the ADR solutions at the TTIPO and all of our initiatives in that regard. So this is a quick overview of the presentation. I'll just talk about the background of the IPO, which gives us the functions that we use for ADR facilities, the roles and functions of the IPO, our MOU specifically with WIPO. Justice Anderson would have mentioned this and Leandro would have mentioned this as well. So I'll just go into some detail on our MOU with WIPO, the implementation of these services, and the intended partnerships on the way forward. Just as a very short snapshot of our roles and functions, we grant IP rights. So I saw in the chat there was a question that Malcolm had raised about how
the EU IPO goes about creating a Chinese wall, as it were, as he put up in the chat. And so we don't actually conduct the mediation because we grant the rights. So I would love to explore this during the Q&A. We promote inventiveness. We make patent information services available. We determine hearings, opposition hearings. Most of the contentious matters that come before the Intellectual Property Office are by way of trademarks. So opposition hearings and validation proceedings. And then as a matter of our National IP Training Center, which was launched with WIPO, we make IP information available to the public. We talk about international instruments, and that's relevant as well. In 2018, we had an MOU executed between the Intellectual Property Office and the World Intellectual Property Organization's Arbitration and Mediation Center. We call it the center. And it was a work in progress even before that. The controller, who sends his fondest regards, worked tirelessly with WIPO and Leandro specifically in getting this done. So in 2018, we had this MOU, and we entered into this collaboration to make ADR options available, in particular, mediation for IP and technology disputes, technology transfer issues through the WIPO Center. And the controller, by his expert negotiation skills, he may not boast about it, but he was in private sector for a long time, private practice, including with Senator Vera. And through his negotiation, we got some of the cheapest rates in the world for mediation through the WIPO Center. And we're particularly proud of that. We have a list of neutrals that are official neutrals for the WIPO Center. I actually believe that Jason Charles is online here, and he can probably at the Q&A section offer some of his perspective, Ms. Fanta Punch, and you'd see Senator Vera as one of the neutrals. We have Dr. Crown and Mr. Lusu. So we have a list of locally appointed IP neutrals that can be used through the Mediation Center, the Arbitration and Mediation Center of WIPO. This is the actual application form that we would have created with WIPO. So you could see the two logos on the top. We have our TTIPO's logo, and we have the center's logo there. And you have all the information, the initiating party, who's the responding party. There's a time period, intended time period, which can be extended by agreement between the parties. And it provides a short snapshot, a short brief description of the dispute that would be happening. So this is the actual application form that parties can use to submit to WIPO for an intention to go into mediation. So ADR and mediation in particular has been at the front burner for the TTIPO and has been treated with some sort of urgency from the perspective of the controller and from the executive of the TTIPO to ensure that ADR options are available and that there's public education outreach with regard to these options. I mentioned trademarks because, as I said, most of our contentious matters that we see at the office are trademark related, and most of our contentious matters, even that we see at the Supreme Court level and High Court level, are at trademarks, in domain of trademarks and copyright. So mediation is especially encouraged for us at the TTIPO when we have opposition and invalidation and removal proceedings at the Intellectual Property Office filed by parties. We send formal communication via letter to encourage ADR, especially mediation, and it speaks about the available options, especially the WIPO Center MOU. So a letter is sent, and usually sent after the end of the evidentiary rounds. That way all the cards are on the table, the parties have submitted their evidence, and prior to any written submissions or skeleton arguments being filed in the matter, we send communication. I'm actually going to give you a snapshot of what that letter looks like here. So it says, I don't want anyone who might have difficulty seeing to try and read this very small print. but I could say that it speaks about the arbitration center and the MOU that Trinidad and Tobago has with the WIPO center. We have reduced administration and mediator fees available. As I said, the expert negotiation of the controller has left us with some very affordable fees for internationally accepted mediations, including the local mediators here. So there's the availability of all these mediators from Trinidad and Tobago and from WIPO across the world. It can be conducted virtually, and post-COVID world, a lot is done virtually. We are here virtually. We're connecting multiple countries here virtually. So it can be conducted virtually, and it's available for the national and international mediators. And we ask the parties to confirm, indicate whether they are willing to pursue ADR. And we have seen many of the matters end, sometimes by negotiation between the parties. We have heard parties say they're willing to enter into mediation. As I said, the formal letter is sent prior to the skeleton arguments and written submissions, but at pretty much every juncture during the proceedings, we verbally tell the parties about the option for ADR and mediation, about the options that are available. And we tell them this is something worth pursuing. It will help you with costs, all the benefits that Senator Vera would have spoken about in the introductory presentation. It would have reflected these benefits to them: time and cost, expertise. You have IP experts for your mediation. In terms of our public education and outreach, and I acknowledge that Justice Anderson said this is one of the elements of public education, working, the CCJ working with CARIPI, and yes, I vehemently agree. We are also, from the IPO's perspective, we have launched our National IP Training Center, which is, we call it the NIPTEC NIPTC. And I can actually confirm that some of the IP neutrals are also certified trainers, like Ms. Punch, who I also believe is online, and we have Nicholas Lusu, Mr. Lusu, who is a patent claims drafter and copyright expert. Ms. Punch she's at Hammersmith, and one of our bigger firms here, and she sees a lot of the trademark disputes. So she has been pushing forward frontally mediation and ADR options. So we work with the IP neutrals for awareness and outreach through our National IP Training Center. The National IP Training Center was launched last year, so we're still in our infancy stages, but we are working fastidiously. So as I wrap up, I'm just going to talk quickly about some of the other models that have been adopted around the world. One of them that we're looking at is the Singaporean model, and Singapore, particularly relevant to Trinidad and Tobago, as we have been modeling many things after Singapore, but Singapore is deemed one of the homes of mediation and arbitration, ADR options. They actually have the Convention on Mediation. So there is the WIPO Arbitration Mediation Center Singaporean office, and there's a collaboration between the ministries. We see that type of collaboration between ministries and the WIPO Center. You could find it on any of these links, and Leandro could expound upon this. You see those collaboration between ministries and even courts. So the Ministry of Law in Singapore promotes officially the WIPO Center as the mediation service provider. And then you see that in Korea as well, in multiple countries. I mentioned Korea because we have a delegation in Trinidad and Tobago from the Korean office here for an appropriate technologies competition. It's happening literally this afternoon, and so that's something that we work a lot with Korea. So in terms of the model, we look at the international framework and international instruments. There's a Singapore Convention on Mediation, and there are, last I checked, 55 parties, including some Latin American countries, Brazil, Chile, Colombia. You have lots of Asian countries, and the US is a party to this convention. So you're talking about lots of countries that deal with trade are party to this convention. It's a uniform and efficient framework for the international settlement of disputes resulting from mediation. And it is something that Trinidad and Tobago is considering. We have many accessions that we're looking towards, IP accessions, and this would be one of them that we would consider. There are other models. Again, there's partnership between the WIPO Center and courts. If you look at the region, you'll see Paraguay, and then you have Korea and Thailand. There are actual courts, if not the Supreme Court of Justice and High Court, you would see their patent courts have a partnership with the WIPO Center for their ADR options. And it is something that we can think about looking at. I'm really happy the CCJ is here. So as I end, we talk about the partnership between the WIPO Center through the TTIPO and our MOU, and partnership with the Mediation Board of Trinidad and Tobago, and partnership with the CCJ. Perhaps something we can explore something like that. It's something that we would have mentioned. Justice Anderson and Senator Vera and I were in a meeting in Alicante together, and it's something that would bring mediation to the forefront, even at the court level and at the CCJ level. So with that, I thank you for your attention and time, and I look forward to the Q&A session. Chair, back over to you.
Thank you so much, Kavish, for that presentation and telling us all about the experience in Trinidad and Tobago. And at this time, I would like to say we're at the end of our presentation. So I would like to thank all of the presenters today.